The following content includes true crime information that some may find disturbing. Therefore, viewer discretion is advised. Hi everyone and welcome in. Well, I really wasn't planning on doing this video, but this is a shocking update to me. I'm sure everyone remembers the Slenderman case. This occurred in May of 2014 in Waukesha, Wisconsin. Two 12-year-old girls lured their friend into the woods and stabbed her 19 times. This was all to appease the fictional supernatural character Slenderman. Now, let me first say that the victim in this case is doing great. She's thriving in life. There have been some amazing updates on her. Everything is okay. So that's the best part in this whole case. What's still tragic is what's going on in the world of these other two girls. Now, Anissa has already gotten out. I think Anissa was more of a follower. I believe that Morgan, up here in the top right of the image, she is the one that is a troubled little girl. There's a lot of mental health issues going on. We literally saw this little girl grow up in an institution with the different hearings that they had from time to time. And then, of course, there was the trial as well. Now, initially, she was denied release, but they've recently came back this past month, and she was scheduled to be released. Now, let me make it known, she prefers to be called a he now. I don't get into all that. I'm looking at a little girl here, so I'm just going to go with what I know. So if I say he, she, and it offends somebody, I apologize. This is just the way I speak. It's the way I was brought up. Okay. So on Friday, there was another hearing. Didn't we go over this hearing on my channel? I want to say we did. At some point, we did go over it. They were going to end up releasing her, but there was going to be some provisions to it all, but she was going to be released. Well, now there's been some information that's come out, and the prosecutor is saying, hold up, we don't think she should be released now. So they've gone back into court, and her attorney is having to defend all of these new allegations, which I don't know. It looks like they're probably true. This is pretty alarming. I mean, for something to happen like this and them not already have this information prior to the judge making his ruling. So let's watch this hearing together and see what happens. Again, this happened on Friday, the 28th.
The court will call a matter of State of Wisconsin versus Morgan Geyser, case number 14 CF 596. Appearances.
Abby Nikolai appears on behalf of the state. Good afternoon, Judge.
Hey, good afternoon. Thank you.
Good afternoon, Your Honor. Attorney Anthony Cotton for Morgan Geyser. She appears by Zoom on the screen.
All right, thank you, and good afternoon as well. Ms. Geyser, can you see and hear the court?
We're having technical difficulties. The volume on this tablet is messed up. My social worker is going to get a different one if that's okay, sir.
Oh, and you see, I can hear you and see you. Are you having difficulty hearing what's happening in court because of the unit?
Is in there. That's happened before.
Ms. Geyser, can you see and hear the court?
I just got a message on Zoom, there are technical difficulties, please hold on, they're not able to hear us.
All right, well, we'll wait a moment. Now, Ms. Geyser, I can see you. Can you see and hear the court? All right, now you're softer, but I can see you and I can hear you. Thank you. And Attorney Cotton, you recognize your client?
I do, yes, Your Honor.
Now, there's just an administrative matter to be resolved. I've been told now the media is fine. Other technical issues have been resolved. Then we'll go forward. The matter I asked for the hearing to be scheduled today, that the court had previously found that Ms. Geyser was appropriate for a conditional release, and I directed the department to prepare a conditional release plan. That's scheduled for Monday at 9 a.m. Yesterday, the court received a statement of probable cause for detention and petition for revocation of the conditional release order. And the court's read the petition. Petition is 6 pages long. So based upon that, under the statute, that's 971.17 sub 3 sub E, the court should hold a hearing within 30 days of today's date with regard to the petition. So the states received the petition.
Yes, Judge.
Any comments on it?
I would just note that we're in compliance with victim rights legislation and we are prepared to schedule that hearing.
All right, thank you. The Attorney Cotton, have you received the petition?
I have, but I'm prepared to respond to that.
All right, well, do you have a response now you'd want to make?
Yes.
Well, go ahead.
Thank you, Judge. As the court indicated, under the statute you're referring to is 971.17 sub 3 sub D and sub E, of course. Under that statute, the court made a finding that Ms. Geyser is an appropriate candidate for release. You directed DHS to prepare a release plan. Instead of doing that, they filed a report with the court seeking to interfere with what the court had previously ordered for two reasons that I can identify in their statement. One relates to a book that Ms. Geyser read, and the other relates to contact with somebody named Jeffrey Pagel, Mr. Pagel, who I have no personal knowledge of who this person is, but the name itself is not a name that is unfamiliar to these proceedings, because that individual it's been a known person to Winnebago, Your Honor. He's a known individual who, from everything I've read that was submitted, it was Ms. Geyser that asked to have a no contact with this person. And I went back to Ms. Geyser's records because I recognized the name, and I saw that Dr. Lundbaum addressed this, and this name was revealed to, I know Ken Robbins for sure as well, who was one of the other doctors in this case. And so you essentially confronted a lot of this already at the conditional release hearing, which was the argument being made that if Ms. Geyser is released, there could be people in the community who would take an interest in her. We've already crossed this bridge. We already know that that is true. We know there's people who will be fixated on her because those people have their own issues for whatever reason. She cannot control that. But when I read this statement that was submitted to the court, what jumped out at me is the maturity that Ms. Geyser demonstrated requesting that there be no contact with this person. That was her request. When she was asked as part of the release plan, who are some of the people that have had contact with you? Winnebago has known every name of every person who's ever come in to visit her, Your Honor. She's inside a locked facility at an institution. There's no surreptitious secret meetings that have taken place. Winnebago has had a decade to monitor every coming and going and interaction she has had. And there is nothing in here that suggests that Ms. Geyser did anything appropriate with this Pagel person. He might be submitting things on the internet that he claims that Ms. Geyser has made or whatever in the past, but she doesn't have internet access. She's the one who asked for no contact with him. And when I went back through the treatment notes, Your Honor, it's in her file. It's in her progress notes by the social worker that in June of 2024, and Winnebago will confirm this, and I can submit the record if you'd like, it was Ms. Geyser sent in a request back in June of 2024 asking to rescind contact with him. Because Ms. Geyser had the maturity and the mental fortitude to realize that there was a problem with the guy. So she initiates this. She says, I don't want to have contact with him. And then when they're preparing for her release judge, she again says, I want to have no contact with Pagel. That's what we would expect a person to do. That's what we would expect the conditionally released person to do. And I want to comment about the literature because, quite honestly, Judge, you've watched Morgan, you've watched Ms. Geyser, you presided over this case now for over a decade. You've watched her go from an adolescent to essentially young adulthood, as have I, as has the state, as has everybody. She is at Winnebago Mental Health Hospital without access essentially to the outside world. Reading is what she does, as you might imagine. There's no internet access, so she reads a lot. Her preferred genre, if you will, is Western fiction. That's what she actually prefers to read. If we were to look at the thousands of books she's read at Winnebago, which, by the way, these are books that are being read inside the facility. There is no suggestion here that she secretly smuggled in some contraband and read a book that nobody could ever know about. She's the one who told them when they asked her, when prompted, what are some of the books you read? She mentions this book. It's not like they discovered a hidden book under her bed that she had been dishonest about. And I would just submit this, Your Honor. I understand you can schedule the hearing however you want, but I don't think it's appropriate to jump into a revocation when they haven't even submitted the plan that was ordered.
I know you guys are hearing some talking in the background, and at first I was like, what is that? I thought maybe I had another stream up or another page up. It's coming from the facility that Morgan's at. I guess they don't have it on mute, and they should.
That's the cart before the horse. You directed them to submit the plan. They ignored your order. They ignored what they were directed to do. They didn't find the group home. They didn't give us any information about her release plan. Instead, they hoisted a concern upon the court about some books. If they don't like her books, then we can fight in court over what appropriate conditions of release ought to be, over whether she can read Stephen King books or can't read Stephen King or Westerns, or maybe no reading. But that goes to the conditions of her release. There has been no showing here in anything that there's a safety to her or others, a safety issue.
Okay, let me bring you guys up to speed with what they're talking about with this other guy. There was a sealed statement of probable cause for detention and petition for revocation of conditional release filed on Thursday, 1 month after she was granted conditional release back into the community. She's now 22 years old. She's been in the care of the state since May 31st of 2014 and has been under a commitment to last up to 40 years after she was found not guilty of attempted homicide by reason of mental disease or defect. Anissa was found not guilty as well by reason of mental defect on account of attempted second-degree homicide and was committed to state care for 25 years in December of 2017. However, in 2021, she was granted conditional release from an inpatient care at a state mental facility and released to live with her father. The petition that was filed by the same department tasked with monitoring Geyser said that she was brought serious doubt to the safety of the community if she's released. So there was a man whom she had a relationship with, and when I say relationship, like it sounds like a pen pal relationship. But now she doesn't want to have anything to do with him. But the problem is that she didn't disclose all about him to her treatment team. And here's exactly what she didn't disclose. Specifically, that he's sexually aroused by her criminal action in the indexed offense. And yet she continued to be engaged with him, allowing him to visit her, write him letters indicating her intent to be sexually intimate with him, sending him artwork of a very violent nature. And the biggest concern is the fact that the treatment team at the hospital didn't know about any of those things because Miss Geyser did not disclose it. They indicate that Geyser gave small pieces of information, and then after she realized there was an investigation, she ended up giving more information. They also said the book that she was reading that they have an issue with focuses on themes of sexual sadism and murder and the sale of human organs on the black market. So these are the findings, and these are why we're back in court. All right, we'll move forward now.
Point where they were seeking to revoke something. That is sub E. But you directed them before that to prepare the report, and they've essentially ignored your order. DHS has ignored the court order. And I think that's inappropriate. I think they ought to be directed to produce that report that you directed them to produce. If we want to fight over who she has contact with or what books she reads, we can have that debate. But to revoke her and then say, come back in 6 months, that's totally inappropriate for what they've alleged here. Thank you.
All right, thank you. Before I hear from the district attorney. I just want to review the petition. I just took the time to reread the petition. So let me ask Attorney Nicolai for her response, if any.
Thank you, Judge. Procedurally, at this point, I understand that the defendant and counsel may be feeling like this is unfair or rash, but legally and procedurally where we are in the statute is that Ms. Geyser is subject and in the custody and control of the Department of Health Services. And the Department of Health Services has now alleged by a statement showing probable cause that the safety of the person or others requires conditional release be revoked. I think that the only finding this court would need to make today is that the statement shows probable cause of exactly that. Because then within 30 days, the burden shifts to the state then to prove by clear and convincing evidence that the conditional release should in fact be revoked. But now that this petition has been filed by the very department tasked with monitoring Ms. Geyser, they are essentially telling this court that, as is described here, in the midst of preparing this plan, they've learned information that has caused them to seriously doubt the safety of the community, essentially. And it's not because of other actors, third-party actions outside of Ms. Geyser's control. I think the information is adequately summed up in the conclusion, and it all is based in the ability to rely on what Ms. Geyser tells her treatment providers and the information Ms. Geyser is willing to provide that the treatment team can use to assess risk. That's the problem. And this court's well aware of that problem because that was the primary problem the last time you denied her petition for conditional release. The issue with this individual that she had this relationship with is not what he's doing on his own. The issue is what she knew of him and didn't disclose to her treatment team. Specifically that he's sexually aroused by her criminal action in the index offense. And yet continued to be engaging with this individual, allowing him to visit her, writing him letters, indicating her intent to be sexually intimate with him, sending him artwork of a very violent nature. The biggest concern is the fact that the treatment team at the hospital didn't know about any of those things because Ms. Geyser didn't disclose it. Similarly, the reading material, Ms. Geyser, the report indicates, gives small pieces of information, and then only when she realizes that investigation has been done and the team has realized additional information does she then open up. The reading material that she's so focused on has themes of sexual sadism and murder and the sale of human organs on the black market, all of these things that the treatment team at Winnebago had no idea that she was so interested in. That's the concern the department has, because they're trying to assess risk. And in order to do that, they have to be able to rely on Ms. Geyser as a historian and as an adequate and accurate reporter. And all of this information in the report throws that into question. And I think that the report is adequate at a very basic probable cause level for this court to accept the petition and schedule the hearing within 30 days, at which then the state will be put to its burden. But at this point, I don't frankly think that the law allows the court to simply ignore the petition that was filed and order this team to come up with a plan, despite them telling the court, we don't think we can make a safe plan for this individual. So I'm asking that we set a date within the 30 days. It's obvious that that timeline is not going to be waived, at which point the state can put its proof forward, and the court can determine whether the conditional release should in fact be revoked at this point. There's no predicate requirement in subsection E that a plan was completed and someone was released already. That's not in the procedure. This court
I think it goes to the granting of the conditional release,
right,
not the granting of the approval of the plan.
correct.
True. Now, I understand, Attorney Cotton, you want to say something, but just relax. You'll get a chance to do that. We'll wait for Attorney Nikolai to be complete.
So at this point in time, I think that the option for the court is to, if you don't find probable cause on the petition that was filed, deny it, at which point I think the department would have an opportunity to supplement it and file another one. But I don't think that this court can force the department to file a release plan when they don't think that they can safely monitor this individual in the community. That's all I have. Thank you.
All right, thank you. Then Attorney Cotton, you wish to make further statements. Go ahead.
With all due respect, Judge, the statutes do contemplate, it's the exact opposite of what the state just said, because under sub E, in order to revoke one's release, the statute specifically uses the following language, Your Honor. If the Department of Health Services alleges that a, quote, released person has violated any condition or rule or the safety of a person or others requires that conditional release be revoked, he or she may be taken into custody under the rules of the department. And at that point, DHS can submit a statement showing probable cause for the detention. Ms. Geyser is not a released person. She has not been released at all because the department is acting prematurely. Their job is to follow the court order, to submit the plan that you directed them to do under sub D. And there's also a mechanism in the statute for when the department refuses to prepare a plan, which is what we now have. It indicates that
What section are you referring to?
sub D, last sentence, if the county department of the person's county declines to prepare a plan, DHS may arrange for another county to prepare the plan. It seems to me what's happening here is DHS is refusing to submit a plan. She is not in any sense of the word a released person yet. Sub E contemplates a scenario where somebody is in the community, the court has acted under sub D, has released them from custody, they are in the community, and they violate a condition or a rule or do some other behavior that endangers safety. At that point, the statute contemplates taking a person into custody and submitting a probable cause statement. Ms. Geyser has never left custody because what Your Honor directed them to do, DHS, was to prepare a report. Now, if DHS had wanted to include this information in its report and said, Judge, here's the group home she'll live in, here's the monitoring we're going to do, here's the restrictions on the reading, here's some of the red flags that we would like the court to be aware of, that's fine. And the court is vested with the authority to tailor that plan as you see fit or send them back to the drawing board because perhaps you don't think it's appropriate. But she is not a released person under sub E. This is a premature filing. It's frankly, it's an ultra vires act by DHS. They don't have the authority to ask for an in-custody person to be revoked from a release that hasn't even happened. It would be like the probation department seeking revocation of probation before you even put someone on probation. Thank you.
State of any response?
Judge, this defendant was a released person the moment you granted her petition for conditional release. Her physical location, the fact that she remained at the hospital during the preparation of this plan does not change what part of the statute we're operating in. Procedurally, the department is the entity who has the authority to seek a different county to prepare a plan, not this court under sub D. Procedurally, the department is the entity that has the authority to petition to revoke conditional release, and that's what they've done. So the location where the person may be held pending that petition includes a hospital, which is exactly where this Geyser is. Judge, my position is that now that this petition's been filed, it has to be scheduled for a hearing.
I've reread the statutes and reread the petition. I'm just going to summarize how I view the statutes. First, the case proceeds under 971.17 of the Wisconsin statutes based upon the court's previous finding that that Ms. Geyser was not guilty by reason of mental disease or defect, and then was committed to the custody of the Department of Health Services under a commitment. Commitment is a lengthy commitment. The statutes provide that once somebody's committed, they can petition for a conditional release. And that's what Ms. Geyser has done on a number of occasions. The most recent petition was heard by the court, with the court granting the petition for conditional release that occurred on a hearing on January 9, 2025. I then ordered that the department prepare a conditional release plan following the statute. The statute provides, that's in section 971.17 sub 4 sub E, and that provides that it states, quoting, the court shall notify the Department of Health Services. The department and the county department shall prepare a plan that identifies treatment and services, if any, that the person will receive in the community. The plan shall address the person's services, residential services, etc. It states that the plan shall be presented to the court for approval within 60 days after the court finding that the person is appropriate for conditional release. That's the step that we're at today, and the hearing on that is set for Monday at 9 o'clock. The conditional release report was not received. The court last week had sought to determine why the report had not been received for the court's review. The only response the court received was the filing of the petition for revocation that came in yesterday, which seeks to revoke the conditional release order of the court. Now, what the process calls for, the court would hear the petition for release. When the petition conditional release, hear the condition, the court would review the plan. If the court reviews the plan, the plan itself is the one that calls for placement and actual movement of the defendant out of the institution to potentially another location. At that time, under 971.17 sub 4, sub 4M, then notification goes out to a number of places and institutions and people that the conditional release is in effect. The issue that Attorney Cotton raises is at this stage of the proceedings, without the plan being approved and the person being released subject to the plan, is the person released? The petition that's been filed under sub 971.17 sub 3 sub E alleges that if the department, that section states, if the Department of Health Services alleges that a released person has violated any condition or rule, or that the safety of the person or others requires that a conditional release be revoked, he or she may be taken into custody under the rules of the department. The Department of Health Services shall submit a statement showing probable cause of the detention and a petition to revoke for conditional release to the committing court. The court shall hear the petition within 30, I'm skipping around in the statute. Then it goes on, the court shall hear the petition within 30 days. The state has the burden of proving by clear and convincing evidence that any rule or condition of release has been violated. That's how I read the statutes. Now, what that means to the court is that I'm satisfied on a technical basis that the person committed is not released until the conditional release plan is approved. That's when the release actually takes place. Otherwise, in this case, Ms. Geyser remains in custody of the department and remains subject to the original commitment order. The statute talks about Ms. Geyser violating a condition or rule. She hasn't of the conditional release plan. I don't see that there's what's been alleged. It doesn't allege that she's violated a rule or condition of a conditional release plan. So that really goes to Attorney Cotton's position with regard to the case. Now, but I don't think the court's analysis can stop at that point. I think the court has to look further into what the status of the case is. To some extent, the allegations contained within the petition seeking revocation are all, as Attorney Cotton argued, are all items that one would have thought would have been known to the institution and would have been available to others who were seeking information regarding. Let me just get back to seeking information regarding the initial hearing on the petition for a conditional release. And that's also an argument made by Attorney Cotton. There's information in the petition for revocation, that's termed revocation, that clearly is information that either was available or should have been available to individuals at the institution exercising reasonable care and diligent care of Ms. Geyser. There's other information in the petition that may not have been available necessarily unless Ms. Geyser disclosed the information that they would not know. Some they did. I'm satisfied. Some of the information that the institution knew or should have known. Other information is that they did not know and would not have known unless Ms. Geyser disclosed it. On the other hand, there's nothing in the petitions that says that she held anything back. It may be that the institution didn't ask the necessary questions, but that's an aspect that the court may have to consider. Looking at everything in the petition, I'm viewing the petition more as a statement to alert the court to reasons why the conditional release plan wasn't provided and the department isn't able to do it based upon their renewed concerns about safety. Now, that, as Attorney Cotton pointed out to other statutes, it says that if the process can't go forward with one county, it should go forward with another county when the plan isn't submitted. You see that more oftentimes, it's more of technical is not the right word, but a staffing issue of whether they're really available and competent to do so. This is I read the petition to state there's information out there that the institution satisfied wasn't considered by the court. It should have been considered by the court in determining determining its decision to grant conditional release. So although I think Attorney Cotton's analysis of the status of the case using the word release, I think he's accurate on that. I'm also satisfied that with its knowledge of this information being available, the court really has a duty to ensure that its decision that came down in January is the correct decision based upon information that's available. And the court would want to then hear the petition. So on that basis, I'll find that there's probable cause to go forward on revoking the court's initial decision to grant conditional release. Doesn't go to release. I understand the other parts of the argument, but I don't think the court can ignore what's been stated in the petition to ensure that all circumstances are fully ventilated, both for the court's purposes, for Ms. Geyser's purposes, and for the community's purposes. So I'll order a hearing. I'm going to try and do the hearing prior to March 21st. So we're going to look for a date before then. I'll assume this could take a day, half a day, a day. I'm also in thought of whether the doctors who did the examination have to be called back in to evaluate this information as to what impact it has on their various opinions. So that's the court relied upon the opinions of the three doctors to a great extent in reaching its opinion as to safety. I want this to be, so this information is something that should be evaluated. Court recognizes some of the information in the petition for revocation should have been known and doesn't really create any major surprises, even if it wasn't known. It's not the kind of information that necessarily would prevent the conditional release from going forward. There's some other information in it that does raise concerns that I think should be ventilated at a hearing. So we've made an attempt to contact the doctors. Have we been successful?
So I'm kind of confused by his ruling because it sounds like he's like, well, this is kind of irrelevant information, but it's good to know because he did have concerns about some of it, and I don't know. This judge confuses me. Mark calls him the judge from the Muppets. Okay, so basically, she was supposed to go into court on Monday, and they were going to talk about her release, like just firm things up about her release. It sounds like, okay, now that's been canceled. So now they're going to have a hearing on the 6th at 1:30 to discuss this further. So they're not going to shut the door on this completely. It could affect her release. It could add some different things to her release. Maybe she's going to have to check in more often. Maybe she's going to have to be monitored better. I don't really know how all that works. We're going to find that out on the 6th. But I will tell you this. We are going to be watching the trial of the Swan Boat Club next week. So I probably will have to report on this either during a lunch break or after the hearing later in the afternoon. So please stay tuned, and I'll get you guys some information as soon as I have it and I'm able to get it out to you.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.